The author of a work typically owns the copyright to that work. However, under the work-for-hire doctrine, the copyright to a work authored by an employee within the scope of employment belongs to the employer. In Avtec Systems Incorporated versus Peiffer, the court considered whether a work is created within the scope of employment if an employee created the work on his own and at home. Jeffrey Peiffer worked for Avtec Systems, which marketed space-related products. Peiffer's job involved using computer programs to produce orbital simulations for satellites. In Peiffer's second year of employment, he developed a computer software program that performed orbital simulations. Peiffer developed the program at home on his own initiative, his own time, and his own computer. Avtec didn't direct Peiffer to develop the program or even know that he was doing so. Peiffer eventually showed the program to Avtec's president and another employee, who identified some minor errors that Peiffer subsequently fixed for an updated version of the program. Peiffer also demonstrated the original version of the program to potential Avtec clients. However, Peiffer's supervisor ultimately told him that Avtec wasn't interested in the program and put Peiffer in touch with Paul Kissack to market the program. Peiffer granted Kissack's company an exclusive license to market the updated version of the program. Avtec subsequently applied for a copyright on the original version of the program. Soon thereafter, Avtec sued Peiffer and Kissack, alleging copyright infringement and other claims. Before trial, Peiffer applied for a copyright on both the original and updated versions of the program and filed a counterclaim against Avtec. The district court found that because Peiffer created the program at home on his own time and initiative, he didn't create the program within the scope of his employment, and therefore that Peiffer, not Avtec, owned the copyright on the original and updated versions of the program. Avtec appealed to the Fourth Circuit.